have asked for some extended time to complete their report. So as soon as we receive the report from the Ministry of National Security, then we can set a date for them to appear before the committee. I wish each and everyone a fruitful meeting. Item 4, apologies for absence. We so far have apologies from Member Clark, Heroy Clark, who will be absent, and Member Sibley's will be late. Are there any other apologies for absence? No? I'm sure this has nothing to do with cannabis, so, you know. All right. Confirmation of the minutes. Members, this...
With amendments, Chair?
Yes, so...
I have a couple of amendments.
So we take the minutes as being read, and now we go to the amendments.
I'm not sure if, based on pagination, will be the same as viewing it on my tablet, but I'll try to identify where I see the errors as best as possible.
All right, so let us just go through page 1, page 2, page 3, page 4.
At page 4, I have the first paragraph reads, Ms. Ashpole advised. Is it the same on yours? Yes.
Page 4.
Advised that the ministry was working on a process that would have eliminated certain procedures.
Start off in the paragraph. Where, what, maybe...
Is there a hard copy that I could possibly get, just for ease of reference?
These are the minutes for June 23rd?
June 23rd, yes.
Okay, because when I'm looking at it on the soft copy here, it doesn't have pages or anything, you know, it just one continuous. So you'd have
can
to
you just hand them 2 of the hard copies?
No, I got a hard copy. I was just mentioning.
Just one from Member Hamilton, please.
Yeah, I was just mentioning that it's 2.
Yeah,
comes up
and it might be paged differently on the...
Right.
So it would be page 5. Sorry.
All right, so we'll go to page 5.
So it's page 5, second paragraph that starts, Ms. Ashpole advised that the ministry was working on a process that would, okay, it was corrected. So the soft copy that I got clearly was a draft.
No problem. All right, no problem. Page 6, page 7, page 8, page 9, yeah. Are you satisfied, Member Hamilton?
Just something there on page 6, sorry.
Okay, want to go back to page 6?
This would be the second paragraph after the listing. And that paragraph starts Member Jackson, but it is the third
line down.
The third line down.
Page 6.
Mrs. Bennett Templar outlined that work that was being done. I think the first that can be replaced with the. Okay, the work that was being done by JBDC.
So outline work that was being done. So take out that.
Right.
Yeah.
And also on page 8, where it says Ms. Graham added that going forward the CLA would be doing the following. Can we move forward? Page 8.
At the top of page 8.
Ms. Graham's added, so it is after the first listing. And it says Ms. Graham added that going forward the CLA would be doing the following, I presume it should say. Found it? No, so Ms. Graham stated is the first paragraph, but below that, after you have the listings, reviewed, increased.
Oh, Ms. Graham.
Right.
Yeah. Okay. Right.
Also, under the paragraph that starts, Member Henriquez, there's a reference there to MIDA's program. It is the MIDA program, no S.
Mm-hmm. Yes, yes. Take off the S. All right.
Yeah, that would be it for me, Chair.
Thank you, ma'am. Can I move for the confirmation of the minutes? As corrected. All right. Member Hamilton and all right. And Member Henriquez seconded. All right. Thank you. Are there any matters arising from the minutes?
There are some things that we had asked for. I remember.
Yes, a follow-up on some additional information. I don't think.
From both Jamaica Development Corporation, we did centers across the country.
Yes, JBDC.
Send it.
Yeah.
The list of centers?
I don't remember. I still have my documentation. All right, but there was still some additional information that PS was supposed to compile to send to us, which I'm sure if the clerk had received it, she would have circulated. So I don't think that has yet been sent to us. Sent to us. Well, there was some additional information on the Cannabis Licensing Authority, and there was some additional information on, I think, Companies Office and the Exim Bank.
I was going to suggest that because we had the continued discussion with CLA and the marijuana thing. I know there were certain further elaborations. Mm-hmm. So just wait until when we get the minutes for the last meeting.
Right. Well, we're the clerk is, because what we want to do is not wait on the end of the period to do one report, to compile one report to be tabled to Parliament. What we have decided to do is do them on a quarterly basis. Right? So we may have a delay in the next set of minutes so that the reports can be compiled. And because what we want to do is to have members of the House participate in the reports, in some of the issues that may be raised in the reports, so that we can have some fulsome debates on it. So I would make a recommendation that the one from Ministry of Industry and Commerce, since there was quite a bit of discussion on the Cannabis Licensing Authority, that done as a separate report by itself. So once tabled, some discussions in the House can be had on the concerns that members had in the committee. We have Ministry of Agriculture and what is the second one, Madam Clerk? And Ministry of Tourism, which will be combined in one report. So we're looking at tabling two reports in the House as soon as they're completed.
Chair, I note your observation regarding the delays in when the minutes, final minutes, and then the report that will emanate from those minutes, because you develop the report from the minutes of the meetings. We are going to go on a break. I think next week is the last sitting before the break.
I would imagine so.
I understand it's about the 20th. We're going to be on a break.
So to do
We're
those
not coming
minutes
back
and then
until about
do the
mid-September.
reports for the.
What I wanted to suggest for efficiency and for convenience of the secretary, if the minutes from the 7th and the minutes of today's meeting, if we could agree to sign off on it via round robin, rather than waiting to come to a meeting, then we could make it more convenient for the clerk to develop the report from that.
Yeah.
That's just a thought.
Yeah.
Because we're going to be out for a good month and a half.
And then
all of August.
And then she utilized that period to develop the report.
To develop the report.
Yeah. Well, we are sitting at the next, supposed to be Heart next week, which is supposed to be our last sitting. Heart Trust NTA.
I don't know, Chair. Miss.
I would urge you to read the report first.
No, the reason why I know about you said the meeting for next week, because there's some scheduling issue. There's another committee that I'm on.
Yes, 28th.
Oh, okay. Yeah. I know it's that other committee.
The 28th. My apologies. And it's good to see that you're up to date with your schedule of committees.
That means we'll be meeting during the break.
Huh? We had scheduled them from before for the 28th. So we got the report. There are some additional information that I think we need to, because in looking through the report that's Hart sent to us, especially to do with the new structure of the Hart NTA, and mainly in reference to the NCT vet, and the arrears because we asked the question, what measures have been taken to collect the arrears? So to give us some documentation on the arrears that is owed to the trust. And also there is, 8th, yes. All right. Okay. We move to item 7, new business. Can you please invite in the Ministry of Justice? Good morning. Welcome to Mr. Bailey, the lone male in the group. Huh? Yeah. But So, welcome to sitting of the PAAC. We invited the Ministry of Justice to just give us an overview of what has been happening and how it is that we're taking a look at the effect of the COVID pandemic on various areas of government and the economy. So we invited you to present to us, and you sent a fulsome report, which most members, I hope, or if not all, would have gone through. So I'm going to invite Madam Pierce with any opening statement that you have, and then we will move to questioning from members of the committee.
Okay, thank you, Chair. Good morning, Chair and members. Let me first introduce the team. To my left is Ms. Shelleen Rennie. She's the Principal Finance Officer. To my right is Mrs. Charmaine Curry-Beckford, Acting Chief Technical Director. Behind her is Ms. Andreen Lindsay, Restorative Justice Coordinator. Next to her, on her left, is Mrs. Ruth Carey-Lewis for Child Diversion, and next to her is Mr. Osborne Bailey, Director, Victim Services Division. I am Grace Ann Stewart McFarlane, Acting Permanent Secretary in the Ministry of Justice. Thank you. Mr. Chairman, the Ministry of Justice has been asked to present today on the status of the Ministry's conflict resolution initiatives, specifically to address the state of the systems and processes in place for service delivery and the projects and programs that have been implemented. As requested, the Ministry of Justice has provided a comprehensive report to the PAAC on its conflict resolution initiatives, or we would also call them alternate justice services. The report provides information on the overall operations of the ministry's initiatives, as well as the budgetary information that was requested, achievements and challenges of the ongoing programs, namely restorative justice and child diversion. The ministry is also preparing to go to Cabinet to seek approval for the enactment of a Mediation Act for Jamaica. The intention of these initiatives is to assist in reducing the number of matters going into the formal justice system, as well as to positively impact the settlement of disputes. The report, you will find, has highlighted highlights of positive impact on the initiatives being undertaken by the ministry. Information is also provided on the number and types of cases received and referred, the referring bodies, program expenditure, and other activities of the program. Thank you, Chair. Over to you.
Thank you. Members, you have the report in front of you and the opening remarks from the Permanent Secretary. I open the floor for questions.
Thank you, Chair. Madam Acting PS, I can understand why Minister Chuck enjoys that ministry and he doesn't want to leave. And Mr. Chair, if I'll get the permission, I'll substitute with Mr. Osborne to work in the ministry. He's in a very envied position by the audience who surrounds him.
Next election, he can probably.
The report was very detailed in terms of the information provided, and particularly the statistical data. However, I have a few questions, mainly for clarification and elaboration. As it relates to mediation services, that is done through primarily Disputes Resolution Foundation.
That's correct, sir.
What portion of the budget comes from subvention? Of their budget comes from subvention?
Well, their total budget we would not know, but we do give them a subvention. That Ms. Rennie, they get 16.3 million for the year from the Ministry of Justice to supplement their.
How much?
16.3 million.
16.3 million.
That's
1.6. 1.6.
1.6.
Yeah.
0.3 annually to supplement their
operating budget. I ask the question, Chairman, because to the extent that we rely almost entirely on that institution for the mediation services, the question of adequacy, right? Do they adequately respond to the mediation services needs that we have? And let me preface that comment with the fact that the importance of the justice system is in regards to our crime fighting challenge that we have. All the studies that have been done indicate that the court system and everything connected there is a contributing factor, the backlog in the courts, all of those other issues. So in terms of national security, it is a critical arm of that. Now, one of the biggest challenges I think we have in the country is the uncertainty and the timeliness of judicial rulings, how long they take in the courts. The old adage that says justice delayed, justice denied. Right. And when people lose confidence in the formal justice system to resolve a dispute, they then resort to their own means of extracting or dishing out justice. Now, mediation is one of the determined channels through which people can have a sense that there's a formal system that can expeditiously help to resolve disputes in the country. That is the context or the background to which I raised the question about the adequacy of the mediation services being offered. Because the other element of it, which personally I'm not too certain about the extent to which the average person out there, the Joe Blow, Mary Lowe, knows about, one, mediation services as part of the formal structure, knows about it, and have some confidence that they can access it to resolve disputes rather than acting in a way that clog up the justice system. That is the background to my asking the question about the dispute resolution foundation and their adequacy.
Okay, member. The ministry is currently engaging the Dispute Resolution Foundation because we recognize, yes, that there is some amount of deficit, and we're collaborating with them as well as assisting them in the promotion of mediation across the island. Currently, mediation is mandatory at the Supreme Court level, but not so at the parish courts. And so, through the instructions of the minister, we are now working on a mediation act with the hope that that will enable the similar mandatory referrals to mediation at the parish court level. Outside of that, there are parish associations, mediation associations across the island, but yes, there could be some more mediators being made available, and mediation comes at a cost to parties before the court or seeking intervention. But sometimes there is a crossover or mix between mediation and restorative justice. Yeah. So while restorative justice is actually free of charge, and restorative justice, Ms. Lindsay will explain more on how that functions. But yes, we also are training some JPs, which is mainly what our subvention to DRF is for, to train JPs to ramp up the amount of mediators becoming available in the program.
If you don't mind, before you go, Madam, can you just explain more detail the restorative justice? Because when I know what the dispute resolution does and what I'm reading here of the restorative, there are some similarity in what you do. or both functions. So if you can give us a little more detail of what the restorative compared to what the justice centers also do. Because you have here where you have 9 restorative justice centers and you have 10 justice centers.
Okay.
What are the differences? What are the functions of both? But if you can give us a little more detail of the functioning of the restorative justice.
Chairman, just a follow-up on Member Jackson's.
Yeah.
Just a follow-up before we go to restorative and the mediation.
Remember.
Madam Pierce, just want to find out if the mediation, if it is dependent only on the referrals from the courts, or you can access it through other means. And most of the mediations are referral from the courts.
That you can, well, we refer to it as community mediation as well as court-annexed mediation. Court-annexed is where matters are referred from the court, but persons from any community can seek the intervention of mediation at any of the mediation centers.
So you don't have to rely on the just
no, you don't
referral.
have to be referred directly from the court to access the services.
Okay.
Before you go, we had Member Holness and then Member Hampton.
Chairman's question wasn't answered as yet, but I would like to add to that. Walking through a particular process, I know a lot of the justice of the peace do mediation that is prior to even incidents occurring that are registered. I am wondering if we can start a process of doing a far wider scope of including justice of the peace in communities and having them document as well the number of cases that come to them and are resolved. It actually helps us to be able to do a comparison between the cost of resolving issues, what we would say on the ground, in the community, in their space, so that it does not escalate to the point that there is an incident that gets to the court system, and see how effective that is. So between the pastors of churches who normally get involved and a lot of our justices of the peace, I know there was a process started through Restorative Justice that somehow tried to incorporate more of the justices of the peace. I think we should really make this a much more far-reaching effort, because when you look at your total number of cases resolved or referred, you have approximately 1,800 cases, but 1,500 is coming through the court system. So many people in communities don't appreciate that I don't even have to go down to the police station to resolve this. We can sit with a justice of the peace, we can sit with a pastor and have them help to resolve the issues. In my own constituency office, I have built a space to establish a sort of option for constituents to be able to come and meet with an attorney once a month, so that you feel a sense that somebody resolving your issues. You don't have to necessarily, my apologies, my phones don't normally ring, so I don't know what happened. So in my own constituency office, what I did, I met with a couple attorneys and I asked them to volunteer their services. So they would come in once per month, and any case at all that you have, you can just come and refer and sit down with them and have a talk, so that it takes some of the pressure off the court system. You feel like you can walk and go somewhere closer, or just jump on the bus or the taxi, and you can go and have a discussion, really in an effort to try and resolve some of the issues that usually result in people attacking one another, sometimes end up killing one another. So I really think if we document and we are able to measure the effect of mediation at that level before it reaches court-style mediation, we would be able to see the significant impact that that has on just the level of crime in the country and just how people resolve and deal with conflicts.
Okay, the point is very well taken, Member. Yes, and the documentation of the work of the Justices of the Peace, we have started some work with them. where they are to submit annual reports. But to get more granular, the point is very well taken that those detailed work that they get involved in, those data could definitely help us in planning a more strategically for their use at the community level.
Chair,
Okay.
just to follow up as well, a lot of the issues that we have in Jamaica stem from communication problems. It's serious. I don't think people understand how bad it is. So I will listen to two people having a discussion. I spend the time and hear them out. And it appalls me to realize the same discussion, the two of them have far different perspectives. None of them know what the other is saying. None of them understand what the other person is saying. And by the time I spend now and say, okay, let me tell you what Chris is saying. And Lorna, this is what Lorna is saying. And then the two of them, oh my God, I never got that. I mean, matters that they're calling the police and ready to fight. But they don't somehow have the ability, and we need to have this ingrained, to listen to each other, to be able to understand each other and resolve the issues.
But before I go to you, Member Hamilton, because I wanted to just explain, because looking at the report here, and to the point that Member Holness was making about the referrals, and if there could be intervention before it even reaching the court, because once it reaches court, that means somebody has been charged and a crime has been committed.
Yes, that's correct.
Yeah? So if you can give us the explanation, because the data here shows that most of the referrals coming from the court and not at the point of when it is referred to the police. Right? So it shows that there's a deficiency in the intervention at the early stage. Right? So can you just, yeah, which is where you want it, because a crime would have been committed for it to reach to the court for referral. And we're happy that the courts are doing the referrals. But if what are the deficiencies that now that we're seeing? Why so little is coming from the police, which could have prevented a crime happening, and how it is that we can get more of the intervention at that point before reaching the court. Yeah, go ahead, Ms. Lindsay.
Thank you for your question. So with regards to restorative justice is really a process which member has just described, wherein the victim...
You don't mind removing...
Yes, of course.
Yeah, so we can hear it
That's
clearly.
better?
Definitely.
Okay, thank you. So as Member Holness has just described, restorative justice is really a process where the victim, the offender, and the community sit down together to discuss what has taken place in terms of a conflict, how they have felt about it, and how they can really move forward together in a way that would promote the likelihood of escalation not occurring. Member just described that when there are two people, sometimes one does not know what the other is thinking. And one of the beautiful things about restorative justice is indeed just that. When they come into a conference, you can almost feel how angry they are towards each other. And as the process goes along and they describe how they're feeling, what happened, their circumstances, and the other person hears that, it's almost transformational to see the change that's taking place. So I do agree with Member that it's very important to have the intervention. With regards to, someone mentioned preventative, we do have an aspect of restorative justice that also speaks to the preventative. We have something called Restorative Practices, and that is where it's a 2-day training, and that really is about really educating communities, that is the police, that is the court system as well, and regular community members, about ways in which they can build trust in relationships, ways in which they can sit down and have caucuses, sit down and speak about issues that's taking place. Restorative justice is an effective program. We're not saying it's a panacea, of course, because we know that crime exists in communities naturally. But what restorative justice seeks to do, and does quite well, is it stops minor incidences and conflicts escalating to more serious crimes and acts of violence. I would say, with regards, you mentioned, Chair, about the court, and the court do indeed, we receive most of our referrals from the court. With regards to the community, I think this is also a time factor. We do complete sensitizations, but we know for people to change their behaviors, it does take time. So our sensitization program is always at work. We're currently having a public awareness campaign on the radio and also to the television. But over a period of time, we have seen the increase as well in community referrals, as you can see displayed in Table 1. So there's a fluctuation, schools, communities, and the police too. We are reviewing at the moment, there is a slight issue as it relates to our policy and our act and the police doing direct referrals once a crime has taken place. So we're seeking to look how the policy can be reviewed and renewed to adequately support that.
But where I'm emphasizing mainly on the police is because what you're trying to do is to, in your words, a small matter escalating to a bigger issue. And if it is that you can intervene at that level, because once, for it to reach to the court, that means the police would have had to be involved. No, well, all right. No.
That's the chair's point in terms of trying to dissect issues that got to the police, but many persons who go even into mediation go straight to court. They get their attorneys and they go to court.
No, but I'm not even reaching mediation, because if you read on page 6, it says restorative justice places a high value on face-to-face meeting between the victim, offenders, and community itself. And I'm using my own experience when I visit my police station, which I have one in Northwest Manchester. You hear the complaint sometime about a cutlass being missing or a fork broken because it lent, but then it escalates into a violent act after when they feel that they are not getting justice. So I'm just saying that in some instances, if you look at it, 1,450 referrals in 2020 from the courts compared to 228. And it is better to prevent from even reaching the courts. And some cases may be that someone goes to the police station, makes a report, but then it is just seen as another report. And are the police then, in this instance, I'm just asking the question, cognizant of the services that they can be able to refer to the restorative justice centers before these matters escalate,
sure,
that you can get more referrals?
Manchester must be different. The police, in many of these spaces, people don't want to go to them to begin with. When they go, they're treated like criminals before they start talking. The level of customer service that persons get at some of the centers is a challenge. So adding to your point, part of what we could do, part of what we could do is literally train them. Yeah. Train police, have them understand and appreciate
that's the point
that
I'm making.
Your police station, your customer service for communities must incorporate this element of preventative.
That's the point I'm making.
Yes.
Yeah.
Because
and that's why I'm saying some of these things may not reach to the courts because there was intervention before. And the greater point I'm making, member, is that to see what numbers come from the court compared to the police, could there be an earlier intervention from that stage before it even reaches to that point? You wanted to?
Good morning, members. What Ms. Lindsay was trying to explain why the police referral is so low is that there's a gap in the law, the legislation. So the police don't have that authority or system by virtue of the law to do the referral. So what you're seeing there are informal referral. Here's the situation with the police. Once a person goes into the station, the matter has to be entered in the station diary. when they refer the person to RJ, once it's in the diary, they have no way of closing that diary entry, because the outcome of RJ is not official to be recorded in the station diary as closing the matter. We are currently reviewing. As a matter of fact, there's a cabinet submission before cabinet coming Monday to review the act, to close that gap and to provide this service.
So that gap was recognized after
it was recognized after the service. So it's the act itself that needs to be amended to allow the police to officially refer matters to us.
I am just saying, because when we, and I know there are always shortcomings when we are tabling a bill to become law, right? And so obviously there was this gap from before. And you're now recognizing that gap.
Yes.
And you're now putting things in place in dealing with that gap.
Yes.
And I just hope it's not staying like many others, even though you have a cabinet submission, because it can help in the prevention of some. And I think that is the purpose of the RJ centers.
Yes.
Right? So, all right. Member Hamilton and then Member Hannah.
Thank you, Mr. Chair. I just want to get a deeper insight into the DRF operations as it relates to the referrals from the Supreme Court. I know as at 2002, the CPR mandated mediation. Mention was made of the fact that it is a paid service. So I just wanted to get an idea as to how effective it has been between the referral stage and the disposal of that process. Is there a lag, if any, and do we have, if any backlog in that process?
Okay. Unfortunately, I do not have a representative from DRF because they are a private entity, and our work with DRF is really one of a collaborative nature and provision of a subvention to them. So their records I would not have here now. But in terms at the Supreme Court, those mediators who are available to the Supreme Court, they are trained by DRF, and then the recommendation is sent to the Chief Justice for approval of those mediators, and then the names are gazetted as mediators who are available to the Supreme Court. And the litigants are able to select, to choose who they will mediate their matters. So in terms of matters that are in backlog for mediation, unfortunately, I will not be able to provide that data now, but could provide it if you...
Well, it would be appreciated, because how do you assess the value of the subvention that you give?
Right.
If that reporting isn't done?
Pardon me?
How would you assess the value of the subvention that is given to the DRF if that type of reporting mechanism isn't in place?
That data comes to us sometimes quarterly through the statistical unit of the Supreme Court, but we did not include it in here, unfortunately, and I will have to provide that. You know, sometimes you do a second read and you realize that some vital data have been omitted. So that can be provided, members.
Thank you, because it would also help to consider or to determine whether or not those services should be expanded.
I think it is evident that it needs to be. Member Hannah.
Morning, everybody.
Good morning.
I wanted to find out, based on the between 2017 to 2020, regardless of the gap, the data suggests that the numbers of police referrals went up exponentially. In other words, from 31 in 2017 to 228 in 2020. So that there is, it would say to me that there is an agreement within the police themselves that they want to dispose of some cases, and that is a good thing. I agree with Member Holness that we do need this kind of intervention, certainly at the police level, at the teacher level, and at different levels of the state. But I don't know that we can be all things to all people accordingly. So the question I have, against the background that in St. Anne, for instance, I have met the Restorative Justice team who came to me personally, introduced themselves, told me what they were about, told me what their services were, and I thought that was excellent. And they had also been going through the community, meeting the various stakeholders to inform them that they were there. But the question I have is, when I look at the types of offenses referred to the RJ program, I see some offenses that are concerning: wounding, malicious destruction of property, spousal maintenance order, wounding with intent. Some of these are really egregious matters, and I'm not clear that it should not be referred to the police first. In other words, if a man go stab me or try to stab me, I'm not going to restorative justice first. I'm going to go to the police first, because in our legal system, I need to make that kind of formal report. So what I'm asking is, how do we therefore, because it's a cultural thing, and I think all of us are clear that we need to get rid of a certain violent culture that doesn't understand dispute resolution or conflict resolution. But how are we going to get to a point where our society understands the law and respects it? And we can't answer that here. But do you verily believe that these matters should not be police matters first? Some of these issues, I believe, should not be restorative justice issues, because at the end of the day, if the restorative justice fails, what is the fallback position or recourse that a citizen has to really prosecute the individual, or to make sure that if something physically, or in the instant case, if it's a custody issue and somebody, or they're not getting their maintenance, what is the fallback position? Does restorative justice currently have the teeth to make sure that a citizen's rights are not breached?
Member, the matters that you have, the offenses you have just mentioned, all those matters were referred to RJ from the courts. So they would have gone to the police. Police would have arrested and charged, placed it before the court for prosecution, and it is a judge or the clerk, in whatever instance, who would have referred the matter to RJ. Now, you had mentioned wounded with intent. Sometimes, as a farmer, clerk of courts, the police would charge for wounding with intent. But when you look at the circumstances and the wound, the matter is reduced in the court and is tried in the lower court. So these are the ones that they would refer to RJ, because sometimes compensation for medical expenses and suffering can be made in RJ. If the parties go to RJ and they do not agree, the matter is sent back to the court for formal adjudication. So there is that recourse if the parties don't agree. So sometimes the offense themselves, just the wording, are strong, but when you look at the circumstances in the court, the matters can be reduced. And these are the matters that are sent to RJ.
Okay, so I'm glad you clarified it. So for the purposes of this discussion and for the public, it is not that the issue can first go to RJ. It has to go to the police first?
Yes.
And then it has to go, okay.
Yes.
Thank you.
She actually indicated at the beginning that the problem was the gap in the law that causes them in the statistics not to be able to document it as being necessarily a police referral, because it doesn't get closed at that level. But I do notice that the informal police reports, which is what is documented here, has been increasing.
No, and I want to make it clear that I understood it. I just don't want our discussion to lead the public to believe that before they make a police report, that they can go straight to RJ first, because I think that is the narrative that could perhaps be construed based on us finding such a wonderful system in RJ and in mediation. Right. So I just wanted to make that very, very clear.
Not for those offenses.
Go ahead, Member Siblings.
Thank you.
I don't want him to carry me to RJ. Go ahead, Member Siblings.
I always need help.
Go ahead.
I agree with Member Hannah with the matter reporting to the police, but I have always presumed that the matters are reported to the police. Even in looking at the statistics that you have here, where the court figure is higher, much way higher than the police. And my experience is that most of the matters, if not all of the matters, come through the police first. But with regards to the matter of whether or not the act is egregious, etc., sometimes what we have found in this court system is that why the matters are referred to the Restorative Justice program is because it involves much more than what comes before the court. It is so expansive that it is dealing with other family members, and the court sometimes see where it is that they will make a decision, come to a conclusion by trial, but the matter is not resolved because there are some other family members that are going to continue the situation. Chair, I find that the Restorative Justice program is one of the best things we have had, and I wish that I have a Restorative Justice program in my constituency, and there's a place within the constituency where persons don't have to travel too far, because I have found that a number of the disputes are within family, and if they are dealt with before, you know, if we can get one, you know, I think the court, the pressure that is placed on the court system will be much reduced. So I'm hoping that you will have a strategy where you can look at and assess what is happening in the court system, the kind of matters that come before the court, and how much of it is resolved, because a number of times the court is clogged up with these family matters, and when they come to court, by the second hearing, second time they are before the court, they are saying they don't want to go on with it, but the matter is not resolved. And before you know it, the same family is back before the court, even with worse incidences. So I would really love if this program could be, Chairman, roll out even more rapidly at an intense pace.
I see the passion in you.
Could you please share with us any link or mechanism to be able to contact you, know where all your centers are? What is the link that we can utilize to direct even our constituents who
Could
may
you repeat that
issues?
for me, please?
Yeah.
Do you have any? Yeah, I don't have that document.
We have, they're all listed on the ministry's website as well.
I think what they're saying.
The Justice Centers. The report.
No.
They're also here.
Yeah, no, but I think what she's saying is that not for really us alone,
yes,
but more
just for the
marketing of the services that can be done. So we hope from this that the ministry and the Ministry of Finance in next financial year will expand your budget for marketing.
Yes, thank you for that. Thank you for that.
Yeah. You know,
and chair, before my friends,
you know,
in.
I'm going to allow you, but next is member Davis,
yes, but
who
just to follow on
to
the listing. Yeah. It's very important for the constituency of Clarendon Northern. I don't see Clarendon here in the listing nowhere, so I'm way up.
Member Siblings, I would not allow you.
Please help us.
All right, Member Davis.
Thank you, Chair.
Member Hannah was pointing out to me that a lot of persons only think that the public defender is where they go with a lot of these issues. So it would be good for us to be able as well to assist in helping them to appreciate the process. I would like to find out if I say invite you on a constituency day and advertise across my constituency that you're coming in and that you're willing to give a talk. Does your budget facilitate you being able from time to time to come out and engage the community if we wanted to put together an event for you to sensitize the individuals? I find a part of our problem as a society is just people understanding, knowing where to go, knowing the process, and it does take a lot of time to educate. So I don't know if your budget allows it. It's only 63 of us, and maybe not everyone needs it.
No, I think one of the main points coming out of this is when we do the report is to encourage the Ministry of Finance the importance of this service to expand their marketing budget. Yeah, and they do have a mobile unit.
Better.
So, Member Davis. Member Davis, go ahead.
Thank you, Chair.
Member Siblings.
Member Siblings.
Member Siblings.
Could you allow me, please? Thank you very
much. Before we refer you to the RJ.
Yes. Earlier you spoke of the Mediation Act, and I wondered whether it contemplated giving the mediators the power to compel persons to attend sessions. I know that mediation requires that both parties in the initial stages agree to it, because you can't have a mediation session unless both parties agree. But very often, as we've just discussed, there are times when the matter that is before the session is very all-encompassing and involves parties who are not present. So very simply, I want to know whether this contemplates giving the mediator the power to allow or compel, well, compel is a strong word, but to invite them then to attend those sessions.
I would say compel, because if you are not interested in, I would compel is what I would love to hear, because if one party is not interested in being able to resolve the conflict, it doesn't make any sense that you're in mediation. And I think the judge would have to frown upon the individual who feels they cannot come to the sessions, not participate in the session, because ultimately it is, in my estimation, disrespecting the court system and the entire process.
Mr. Chair, I believe the question that I asked earlier in relation to the efficiency of the DRF vis-a-vis the mandatory mediation matters would help to answer this question. Because, you know, we could mandate it, but how does it work?
All right. Would you like to? You understanding the question?
Okay.
All
right. Well, given, as you have prefaced your question, that mediation is a voluntary thing. However, to complete the process is important in order to keep matters out of the court and to reduce the backlog. So it is something we can consider, because the legislation is just in its draft stage. We have just completed the strategy and the legislation is being drafted. What we can do is explore to see how best compels, might not be the word we want to use, but it may be that we can find a way. And may I just indicate, for example, mediation in parish courts now in criminal matters under the Criminal Justice Administration Act. once the persons agree, we canvass mediation and they agree, the form that they sign says you have to complete the mediation, unless if you don't, the matter returns to the court and we're going to trial, and it's not a win-win situation here. So they are encouraging that way. So we can put things in the legislation, maybe in the schedule, the forms, to ensure that persons complete the process, given the consequences of not completing the process.
Just to pick up on that point, an addendum to that point, I hear you and the discussion with my colleagues about whether you instruct, coerce persons to participate at the community level, which I think is one of the bigger concerns of all of us here and others not here, at the ground level. What I have found is that persons who are initially reluctant, they're upset, so vexed with the person, they don't want to go into mediation. But if you get somebody in the community that they can listen to or trust to be that intermediary, you can get the person to come to the mediation process. So I don't think we should be distracted or discouraged about the probability or the tendency of persons to not want to. Granted, and I accept it has to be voluntary, but I believe there can be some pre-mediation exercise or preparatory, supportive, whatever the right description is, to get those persons to participate. I have engaged persons towards the process that, from reports I got, they will be reluctant to participate. But somebody who they trust, somebody who they believe in, can convince them to participate. One last more question. Can you give a rough scenario of one of your justice centers, how they operate? And again, my reason for asking that question, and some of my colleagues, like from North Carolina, about whether one is in his parish. I looked on the list too. I never saw any for Portmore, which is
Members, I am protecting the member on this one.
No,
Member, please, member, stick to the question,
Portmore
please.
Portmore
is not a parish.
Portmore is not a parish, but Portmore is a community that is very dense. And I know no one will support creating multiple parish in the corporate area because of its size, in the same way they want to create a parish in Portmore merely because of the number. But I looked at it and I never saw one. And let us be frank. All of us as MPs would like one of these in our constituencies and parish. But from where you are, there's another dimension to it, the administrative efficiency of setting up these fixed infrastructure and the operating costs and so forth. So you have to look at a more optimal way of utilizing your resources while providing the services. So I was just wondering in my mind to get a sense. Maybe I need to visit one of these centers, spend a good portion of the day to get a feel as to how it operates. Because I think about some kind of mobile centers. So for example, in an area you could say once a month, restorative justice service is provided, and then the promotions and so forth could take place around it. Okay, you probably don't need more than a month in that area, or once a month or twice a month or something like that. And you use some existing facility, either a public library or some other space, physical space, and you don't have no additional recurrent costs to maintain. Those of us who serve on the executive side of government, we know that these are realities that you have to deal with in balancing the expenditure, but at the same time responding to the needs that you have out there. So it's from that perspective I'm just positing whether or not some sort of mobile, periodic center operation in select areas where there's high demand.
I would want to add to the member, he went down, even though I'm laughing at him, Reese, Portmore not being a parish. I agree with him. I was actually going through and I noticed that the centers were set up in Trouble Zone, Denham Town, Tivoli had, Augustown, and I started to get a sense that you were strategic in some of the spaces that centers were established. It would be good if you can give us an idea of what's the annual cost to run one of these centers, so that we would have an appreciation if we had space and you could come in, or if you can come in from time to time, we would be able to facilitate your being given the opportunity to have, even until the time when you set up mobile centers, which I think is an excellent idea, a space you can come into. I definitely have space that can facilitate your coming in. I noticed you had Olympic.
I hope you have the budget to the space.
Tivoli, Augustown. So if we are able to provide the space, what sort of cost would it be looking like? If you can. Right, I was thinking CDF could actually facilitate an allocation, even once a quarter, for you to be able to come in if we have cases.
All right. Would you like to answer? Madam Pierce.
Okay.
Would you like to answer?
Okay, yes. Yes, members, from what I am hearing, it does appear that RJ is very well needed in most constituencies. We may need to ask Minister to canvass and get some data as to where, so we can prioritize. But yes, the operational cost is a big consideration, because we're talking about staff, utilities, programs, and if we're not paying rental, some spaces where we're paying rental. But if I may, before Ms. Rennie explains the annual cost, earlier Chairman asked about the difference between the RJ centers and the justice centers. And Member Honis also pointed out about some of the centers being in some volatile areas. RJ program came out of the West Kingston social inquiry. And so they were initially mandated through the CSJP program, that's the Citizen Security and Justice Program, to establish centers in then what were referred to as the CSJP communities, in 50 communities. However, with the growth of the program, the ministry, through our minister, came up with this idea of establishing justice centers where they would be co-locating child diversion services along with restorative justice services. So persons requiring these services would not be going across the parish to access the service. So the justice centers are more like one-stop, like a one-stop shop location. And so we are seeking to build out more of those across the island to absorb some of these services, as well as to maintain the existing ones, and probably looking.
So why not mediation services offered in the
that is definitely in the centers that we are seeking to establish now. That is also a big consideration, big part of the planning, not even just consideration, to make these centers more purpose-built to accommodate the delivery also of mediation, because some of the mediators do have a challenge in identifying a space to conduct their sessions, because some of what they charge, and the difference with mediation and restorative justice is that one charges, one is free. And also restorative justice, as it says, more seeks to heal and build relationships, while mediation, you just agree to settle a difference. So there is no push to build or maintain a relationship.
And why? Because coming back to Member Hamilton's original point, just like with the Ministry of Education, where they have this micro-care, which is an assessment of a child that is challenged, which is supposed to be a government service, but there's a cost. And the cost is, most times, an inhibitant to persons accessing the service. Yeah? And so why I ask the question if it cannot be a part of the complete overall service that is offered in? Because right now you have just the DRF that offers that service, but then can we gain more? Because as you've been repeating that it is a paid service. And I'm looking at the financials here. There's $16.3 million that is spent, well, $35.3 million that has been spent from between 2019 and 2022, the end of this budget year. And I would imagine this is a $16 million that you referred to earlier.
That is used to assist with training of JPs.
Exactly, right? But then you come down to restorative justice, and one of the things that we try to do at the committee is to see if there is adequate funding of these programs, especially when they're successful. Yeah?
Yes.
And
previously, though, if I may, the restorative justice and child diversion services were mainly funded through the
EU.
IDB, Global Affairs Canada, and DFID, with some government funds. But though that support came to an end in December 2020. And so
it's
it
now
is just
coming from central government's
into
funding.
government funding fully. Right, and so, yes, going into the next fiscal year, we'll have to try some robust advocacy to get some more funding for the program, which you all have recognized to be very effective programs. Remember,
so what are we
do have a restorative justice center in Maypen.
So let me ask though, but if we look on page 29 of the report,
yes,
mediation.
Page 29.
Yeah. Yes, that back
Yes.
page. Mediation,
Yes.
and this would be referring to the DRF, the structural cost. Because if it is not a government entity, are they housed in a government building? Or what is the structural cost being spent on?
Some, I am told, are housed in government building. I know, for example, in some parishes, we do share location with them, but not all.
No, because why I'm asking is if you're subsidizing them, and at the same time doing repairs to facilities, which is then, for me, if you're spending 88 million over the period, the same period, for structural costs, compared to 35 million, and then it is still a paid services to those who are using it.
Okay,
what is the benefit?
will explain that.
What is I mean, there's an overall benefit, but what is the additional?
The structural cost is not for mediation. That's an error.
No, well, here it's put under mediation.
That's
so
an error in the report, Chair. The structural cost is really for the justice centers.
Pull down the mic.
The structural cost is really for the justice centers.
Mainly for the justice
centers, RJ centers, and child diversion.
Okay, all right. So this is not, but right. How it is labeled here would give you the reasoning that's this. All right, thank you. Sure.
Try something and maybe just bring some light to what you have said in terms of treating with mediation in a way that is affordable. The strategy that we're working on now, it calls for mediation to be accessible across the country to the ordinary person who cannot afford it. So we are looking at a legal aid type strategy. Good. So if a person will create a pool of funds, that is a thought, that's a thinking behind the process that we are undergoing. You create a pool of funds. Two persons are before the court. They cannot afford mediation. The government subsidizes in a legally kind of way these persons so they can access the service. That is what our strategy is looking at, and that is what we're actively thinking about. Regarding the mobile justice centers, we are in a position to consider the suggestion because we do have mobile units that do legal aid for free. So we can convert those units to justice
to do both services, yes.
Interchangeable.
Yes.
So we are in possession of and they are equipped with different telecommunication devices that can assist. Well,
do we book?
We are taking your suggestion, so we're going back
right
to think about it, to put it in place so that we can treat with it. So we are taking your suggestion because we have the infrastructure.
Because I remember there was an invitation for members of the House to utilize that legal aid services that you offer.
Right, but for
yes,
RJ,
so
we can book for legal aid, but for RJ, we are going to have to take your suggestion, think it through, and organize it.
All right, that's one positive. Member Hamilton and then Member Silvers.
I know the Child Diversion Program is a new program, but on page 22 of your report, there is a CD referrals to specialized service.
Page
22.
Okay.
You have here number of children referred to counseling sessions, number of children receiving substance abuse treatment, and the number of children receiving sexual and reproductive education and counseling. In that report, I realized that Trelawney is higher than every other parish as it relates to the referrals. With numbers such as that, how do you use this data, or is it funneled or channeled anywhere that you can drive certain types of community intervention? Because it is obvious from the data that you have there that there are certain issues that need to be addressed within communities or within parishes. How is that data utilized?
Thank you, Member. The data for Trelawney, I must correct, has an error in it. So let me just, that we need to correct that in the document.
So we're not that high?
Showing, right, it's showing it's not that high. If you actually go to page 23, you can see the number of children that were referred for each parish to child diversion from the court and from the police stations. When you look at Trelawney, during that last year, we only had 6 children referred. So that would have been an error on page 22. So of that 6 children, 6 received mental health, 5 received support from National Council on Drug Abuse, and 2 received referrals to Women's Center Foundation. Just to make that correction.
Thank you, because that was cause for alarm for me.
Right, but the Child Diversion Program has several service providers that we work with. When every child that is referred to the program receives an intake and a risk assessment, and the criminogenic factors and risks are identified, and therefore the treatment plan, it results in a treatment plan, so it is used.
How has the program been going so far? Have you had any difficulties dealing with these cases, and has it been efficient?
All right. The program is in its infancy stage, so we've been operating for just about 1 year. And one of the objectives of this program is to ensure that children are not entered into the formal justice system, right? Not institutionalized. So if you use that first as an indicator, you can see where we had over 300 children referred, which simply means that 300 children were not exposed to the formal justice system and are being treated in a way that not only addresses the offense, but addresses the root cause of the maladaptive behavior. So that, to me, would be the first indicator which highlights that the program is doing well, with the hope that we will have an increase in children referred to the program. We are expanding our services that we can offer because, of course, as we identify risk in children, we recognize where we need to establish more partnerships with our external stakeholders to make sure that we are providing a very holistic treatment program for each child.
Just as a follow-up, could you just identify some of the services that you provide under this program?
All right. So if I may, just to give you the process first. So the process is when a child can be referred to the program by the police and the court. Not every child that is referred to the child diversion program gets a treatment program, which is referred to as a child diversion program. Because some are just referred because the matter was so minor, they're low risk, they really just don't belong in the system, and they go home. For those that enter on a referral, which is from the police or the court, we do a risk and intake assessment. We develop a treatment program. That treatment program is developed by a child diversion officer with other experts, and it goes to a parish committee, which reviews the treatment program, assesses it, determines whether it needs to be modified or if anything else should be included, and approves that program, and the child signs a contract in which they are to follow through with, right? So now we speak to compliance and non-compliance. Now, in terms of services, what we have seen is there are a number of offenses that we receive in the program because the legislation, the policy initially spoke to minor offenses. However, with the court being able to refer children to us, we have a range of offenses. The majority, I would say, is a child having sex under 16. So we do have an agreement with Women's Center Foundation of Jamaica, who helps to support teen mothers, young fathers now, and provides educational counseling and reproductive health counseling for our children in the program. We also have several mental health providers. We do have National Council on Drug Abuse. We work with Heart Trust. If we see the need for apprenticeship programs, we have, we work with Child Protection and Family Services Agency, probation aftercare officers with the DCS, Ministry of Education. So we have a wide cross-section of services that we have available, and we do need to continue expanding the private partnerships for psychologists and psychiatrists.
Realize that the intervention is quite comprehensive, which is good. But you mentioned earlier about the child signing a contract.
The parent and guardian.
Okay, good. I just wanted to...
Yes, let me correct that. Yeah. Thank you for that. However, for this program, I just want to note that the legislation allows a child under the age of, above the age of, is it 14, to accept responsibility and therefore agree to participate in the program. Yes.
Chairman, I don't understand that. And the reason why I don't understand it is because even a child cannot go to a clinic and ask for birth control if there is not a parent or a guardian with them. And under 16, there are certain things that they can't do. So how is it that a child can sign a contract to do this at 14 years old, giving consent to legal issues that they might not be aware of? Yet in our legal system, there are other things that they can't have access to unless they're 18.
Or what is it that they're allowed to sign to in that contract?
No contract they should be allowed to sign to.
No, go ahead. We'd like to hear.
Thank you for the question. So the legislation that was approved, the Child Diversion Act, it specifically states that a child, so there are certain mandatory requirements for a child to participate in this program. Acceptance of responsibility is similar to restorative justice principles. The victim agreeing for the child offender to participate in the program. The parent and guardian agreeing and the child giving consent to participate, because it's difficult to treat with a child if the child doesn't want to participate. So the legislation allows a child to agree to participate in the program.
If so it's really a social contract?
It is a social contract. But for the contract...
No, hold on. I want to know if it is with the consent of the parent.
The consent of the parent and guardian must also be given.
Chair, I think it is more than that. What I'm hearing...
Member Sibley's, hold on. Let her just answer the question. Answer the thing first. Yes, waiting on you, Ms. Carrie Lewis.
While you wait, can I state what my interpretation is based. My interpretation of what Mrs. Lewis had said is that the parents or guardian is there, the child 14 is there, but the sense is that even though the parents might have agreed for the child to be there, there's a sense that the child need to take some responsibility, and that is not whether or not the child is going to participate without a parent consent, but it comes down to the child, the perceived responsibility. That is what I'm getting. Is that the case?
Right.
And I keep saying, Mr. Chairman, with the love and respect I have for the member, I don't want him to tell me what he perceives.
No, I'm not telling you. I'm telling you what I have heard. I'm asking now.
Because I want to hear from
Yes. All right. Okay, member Sibley's and member Hannah.
Sorry, I want to make sure I find the section for the member that's asking. If you could just bear with me while I look for that section, please.
Definitely.
From it, she said the parent or guardian would have to consent, the aggrieved party, and the child would also have to consent at 14 years or older that they also want to be a part of the process in taking some element of responsibility.
Chair, so as not to delay the committee, are we able to provide the committee with that clarification?
No, not a problem. Member Sibley's, you had your hand up earlier, and then.
Earlier we were talking, Chair, with regards to the cost of these centers, but I don't like to look at cost in the same way that most persons look at cost. I like to look at cost in terms of a cost-benefit analysis, because if we look at cost to say that it is $3 billion, $2 million, or so on, we might not make an informed decision. What I would love to hear, if we have a restorative center in the 63 constituencies, how it will impact the cost for the criminal courts and the cost at the hospitals in terms of the centers that you have set up so far. Prior to going there, what was the statistics for a number of things? And now that you are there, what is the current statistics? Amount of cases that goes to the court, the amount of, does the emergency room for the hospital that is there, does it reduce the cost? And that is what I mean by a cost-benefit analysis in putting together the cost, because once we just look at the cost of the recurring expenditure, that is good. That is good in terms of what we have to spend, but it would be a much improved data if we are seeing that it is reducing, even though we are spending $1 billion over here, it is impacting a reduction of $2 billion over in our next sector. So that is what I would love to get.
Mr. Chairman, before they answer, can I just ask one question? Are there any offenders under 18 that are automatically referred to child diversion? In other words, are there some acts committed by minors that are so egregious that at the end of the day they have to be treated in the formal justice system?
I think it's a two-part question, because one, we do get referrals directly pre-charge, right? In other words, the police can directly refer to child diversion for specific offenses. The schedule of offenses in the legislation are mainly minor offenses. I would say there are only 2 that could be perceived a little bit more major to some, which is a child having sex under 16, but you would know that that is something that we are constantly seeing recently, this offense, and it needs to be treated with. And incest is also on the schedule of offenses. The police are only limited to refer children to child diversion based on the schedule of offenses. However, the court can divert any child to us based on the legislation, a child in conflict with the law, a child in need of care and protection, and the legislation goes as far as to say any other child, which would then allow us to take now children who are deemed uncontrollable.
Haven't we addressed the legislation for uncontrollable yet? That a child does not need to be remanded for uncontrollable behavior? In other words, has that been amended? And also so those are the only ones. So for instance, if someone under 13 was to shoot or allegedly shoot and kill someone, can that be referred to child diversion?
No, that's not on the schedule of offenses.
Amendment you're referring to, uncontrollable, that piece of legislation falls to education, where care protection is.
So with the restorative justice, the police can't really make the referrals because there's a gap, but with the child diversion that was put in, yeah, it's in there. Member.
Ms. Query, the data that you provide on the child diversion, and I know it's pretty early days since this program has been in effect, but a couple of things jump out at me. When I look at the Parish Breakdown, when you look at Portland, you had 39 cases, St. Thomas 56, and St. Mary 56. These are all 3 rural parishes and relatively small parishes. And you compare that to larger parishes with larger urban centers, the corporate area, Kingston and St. Ange, if you conjoin both, that's 50, right? And St. Catherine, for example, 14. Those numbers jump out at me. St. James, 21. It's a large urban center. But those 3 parishes, could you, any data to inform what are the particular nature of those cases, why we have those high numbers in those?
Okay. Let me first start with, because it's a program that just started, it's in its infancy stage, The first year would be the implementing period. During the implementation, you are sensitizing your court professionals, you're sensitizing your judges, your clerks of court, your prosecutors, and you're sensitizing the police. So what you'll find, you have some parishes that buy in right away. It's not necessarily a reflection on the types of offenses in that parish or the population, because if you think about it, St. Mary generally has a low population of children offending, right? So the parishes that you listed, St. Portland, St. Thomas, and St. Mary, it's the same judge that sits on that children's court because it's that region. And that judge right away bought into this program and therefore referred right away. As soon as we opened our offices, they started referring cases, yes.
One of the virtues of this appearance before this committee, and perhaps you need to have a discussion with the Chief Justice, is that, as you said, the judge or the courts that have a early buy-in, you see this kind of response, which is really, we want to have a system that is responsive to needs out there. Because what I'm interpreted from what you're saying is that though these numbers are high, it is not that the cases are exceptionally higher. They can also be high in other areas, but because of the low buy-in or slow buy-in, that the service is not being accessed as much as it could be. My last suggestion at that point is that when you make these reports, you must put little footnotes so that we don't get baselessly alarmed. Right?
Thank you. Sure. Just for the benefit of the committee, I looked up the Child Diversion Act, and at section 9, subsection 2, speaking to the referral of the child to the program, it says a child referred to in subsection 1 may be considered for referral to a child diversion committee for participation in a child diversion program, A, if the child accepts responsibility for the diversion offense without having been unduly influenced by another person to accept responsibility, B, if there is a prima facie case against the child, C, with the consent of the victim of the offense if identified and located, and D, with the consent of the child, which shall be given in the presence of 1, the parent or guardian of the child, 2, an adult other than a constable who is present with the consent of the parent or guardian of the child, or if the child has attained the age of 14 years, the consent of the child, or 3, an attorney at law acting on behalf of the child. So that has been our issue for
the question that was asked. Thank you very much. Members?
I really had, pardon me, Director Acting PS, had another part of my question. In much of the discussions this morning that there's a consensus about the mediation, and you were speaking, Acting PS, about mitigating the costs. Sorry,
I was just saying, I was just going to ask if we need a mediation.
I'll make it easy, Chairman. I'll direct it to both.
No, because I realize we're onshore, but
yeah.
Actually,
I'll direct it to both. I'll direct it to both.
That is acting PS. Yes.
You know, the cost factor in these mediation services, and you mentioned about the legal aid type approach. I've having a challenge in my mind about how adequately are we accessing lay magistrates, right? Justices of the peace. And I'll be frank with you, I might get knocked by some today. Many people want to be justices of the peace. And I question how much is it the office and the title they want, or is it to provide the services that the communities need? And I say that too because I get report that justice of the peace in parts of my own constituency that are not accessible by persons in the community. But there are many people who want to be justice of the peace. So on the one hand, if as I understand the role of justices of the peace in communities, it's a good thing to have people want to serve in those capacities. in that capacity as Justice of the Peace. But on the other hand, are we getting sufficient services from them in those community voluntary capacities? Two, I welcome, for example, greater scrutiny in terms of the abilities of the persons to provide professional services. For example, if we can get like more lawyers who become Justice of the Peace to function in those capacities where we get the benefit of their legal training, or other persons in other professional areas where those competencies can be brought to the fore to provide in mitigating some of the dispute issues and that we're at the community level. So in summary, Madam Pierce and Ms. McFarlane, the usage of justices of the peace in the mediating function at the community level, because while we talk and we contemplate, there is an urgency of having these accessible services at the community levels, and we have to use all available human resources that are available there, notwithstanding how discouraging this cost, this budget item that might appear to deter some more intervention, because some is being done.
Well, member, let me start by saying that Justice of the Peace being held accountable, that has changed under the new legislation. They are now required under the Act every single year to produce a report of their activities to the custodies. If they don't, the Act, that section of the Act says they can be decommissioned. So that is one thing. Yes.
Yes, that's what bothers
CTD.
me.
That's PS. PS over there, CTD over here.
You all. I want to make it easier for myself. You all, right? And it goes to wherever it rightfully belongs. It's Beckford. It's like laws. We have a lot of laws on the books, but whether we are realizing what the laws provide for is another thing. When I hear you talk about reporting, and they can be or may be decommissioned, it gives me no comfort.
Well, remember, may I continue? I was going on to say something
Mrs. Beckford
else.
Finish her response first, and then.
That being said, the Ministry of Justice, we have been engaging Justice of the Peace over a period every single Thursday. Well, every other hour, at night, 7:30 to 9:30, using the virtual platform, engaging them, educating them on issues like child abuse, issues like the COVID situation, how to treat with. We have even gone as far as to educate them about paying your taxes online so they can get citizens in their community to pay their taxes online to keep out of the centers. So what we are doing now is, apart from mandating them, we are equipping them with the necessary tools and information to go back into the community and serve in other ways other than just witnessing signatures. That is expected to be reflected in the reports that they provide to us, to the custodians at the end of the year, that will come into the Ministry of Justice. So we are not just we're not just putting sanctions on them, we are equipping them with the necessary tools, necessary information. As a matter of fact, the child abuse session is taking two parts. Part one was last week. Another part is to come because we are bringing in, I think, the CPFS to do the necessary things. No question and answer session can be longer, so they can get all the information. So apart from the sanction, they are being equipped. So those reports that come in to the custodies and then to the ministry should reflect this increase in their interacting with the community.
Yeah, fine. I think that, Ms. Beckford, where I was really going is that when you have, say in a parish, you have 200 justices of the peace, and you said the reporting is a requirement. A report comes in for the end of June from that custos, right? How early is that report reviewed, identify the non-functional persons, and how soon are they disbarred? I mean, not disbarred, but they decommissioned, right? Because you know what happened? It is only when people recognize that there are consequences to certain failures that they will act to prevent the consequence from occurring. So I was a bit not so heartened when you just tell me about the reporting and then what may happen. Because invariably, many of the times, these things don't happen.
Well, remember, I can reassure you now, we have a unit, an entire unit at the Ministry of Justice dedicated to the justice of the peace, their functions, and to uphold the sections of the law that we need to treat with. So the follow-up, the system for follow-up is there. So when the report comes in, it goes to a very senior director who will peruse those reports and give the report to the permanent secretary so we know we can act from there. So there's a whole unit dedicated to that process.
I want to direct something to Mrs. Stewart now.
Yes.
Not to both of you. Ms. Stewart, I will make a kindly request that I would like coming to, well, in my own capacity as an MP, a report, whether it is half-yearly or annually, of how many JPs have been decommissioned over a given period. Right? If you could provide that to us through the clerk, that would be useful. Because what I want to go out there is that persons who decide to become JPs, so that once you make up your mind to offer yourself as JP, and we're going to bestow you with this title and office of JP, we are expecting something in return from you for the communities and our country. So you only have serious persons coming forward.
Will do, member. The provisions are there in the Act. We just have to rely as well on the custodies to whom they report to enforce these where they, the JPs go afoul of their commitment.
I fully support the member Jackson's observation as it relates to the services being offered by a number of the justices of the peace. I'm a senior JP in my parish, and the amount of work I have to do sometimes, and I see a lot of JPs, and then do nothing. Yeah, so I support the view that.
And I wanted to support as well, Mr. Chair, because in my constituency, I am aware of a number of JPs who have migrated and they're still in the system, they're still on the books for the ministry, because I personally went and checked the ministry's website to find out whether or not if these persons are still listed, and they're still there. So I do agree that we need to do the enforcement aspect of it. And there are persons there as JPs who people just cannot go to. They will never help. So I don't know how you can, write that, but it is a real concern, and that is why you have JPs like Member Witter who will always have work to do.
Member Sibley? Member Sibbs?
What I'm asking, based on Member Jackson's question, is not just a report that gives the total number of JPs that are decommissioned. What I want to see is how many have been reported as well. How many JPs have been reported, and how many have been decommissioned, so that we can get an understanding of the effectiveness of the unit, or the efficiency in which you because I'm hearing from Mrs. Beckford, that you have a unit set up for this, but what we are saying from this side is that there's a lot of challenge with persons within our constituency when they go to justices of the peace. They are told a number of things and they just can't get any assistance. So we need to make sure that the unit, one thing to hold these justices of the peace accountable, but we want to make sure that the unit that is set up to do the work and carry out the work, they too are effective.
But, yeah, and including in that report just an outline of the assessment that is done that through the unit of these individuals, because what you really don't want is that you're trying to fill in gaps, but you go for quantity instead of quality. Right? And we see, I remember while growing up, a justice of the peace was not only just a respected person, but now, as Member Jackson said, every person now feel that they are qualified to be a JP for the title of just being called justice. And if it is a service that is, you're offering a service, and you have persons within the system for a very long time, but it's still on the list, as Member Hamilton says, but is not in a position to offer the service as before, is something that needs to be looked at. But what I think is more important is the assessment of these persons that you commission as JPs. And if it is that they are giving the service that is required of them, if not, then how long does the process take to identify these individuals of not providing the services that they are? And we know it's voluntary, because when I heard just last week the stipend that Augustus receives, I wonder why anyone outside of just the love of service would take on. No, and it is a serious matter. It is a serious matter, because as much as what we do in here is service also, there is also a cost to providing that service. And I realize that some justices find themselves in that position and is caught and decommissioned. But it is how efficiently the mechanism works in identifying the ones that are not providing, and how long the process takes in getting them out of the system that you can fill in others. All right? So, members?
One question that you can help me with. I heard the term used there a moment ago, and I've lingered in my head for a long time. What is the proper title or formal title for justices of the peace? How are they addressed?
Microphone, please. Microphone.
The act does refer to, it says justice, but they're really Mr. or Mrs.
They're really?
They're really Mr. or Mrs. or whatever, but I know they really do enjoy being referred to as justices.
I have a little problem. I heard it. I asked the question deliberately because I've heard it.
Mm.
And
no, they're not. The justice is reserved for the High Court.
Exactly. That is the question. That is exactly why I asked. I am familiar with justices being referred to members of the judges.
The judiciary, yes.
Puny judges are too, right? Mm-hmm. Now, when I hear that, I hear the term being used to refer to justice of the peace of justices. I believe you guys need to give a formal instruction.
No, it is a cultural thing, though.
No, it's not no cultural thing. It never used to happen so many years ago. It's a recent thing.
It's culturally. The persons refer to them as justices are the answer.
No, and I went to frank with you. If that title is reserved for our judges at a certain level, right? It is not fair for the formal system to allow persons who don't belong to that grouping to be so addressed. So you must give firm, clear instructions for justices of the peace that they are not to have themselves be so referred to as justices, as that title is reserved for judges. We must have some order in this.
Member Witter, do you enjoy being called Justice, Witter?
I'm not called Justice. I'm called MP. but as Member Jackson said, what happened in the communities is that they really see you, because from time to time
you sit in petty session and everything.
When you do this,
exactly.
Session,
so it's a cultural, you know. I understand what the member is saying, but especially you see he's an urban MP, you know. So in our instances, persons' pride in calling the justice of the peace justice. I grew up with a granduncle. The whole community call him Justice. And he's dead now, probably 30 years. But if you go into the community now, they refer to him as Justice Gentles. Yeah? So it is...
Mr. Chairman, it's one thing for people to have a pride in calling somebody Justice. It's a different thing for people having pride in being called Justice. That's a big difference.
But I understand your point. Members, are there any other questions? The final thing that I want to just, and we have you here, and we've spoken very proud of the two programs, the restorative and the child diversion. I want to hear from the ministry itself, what are some of the challenges that you're facing with these programs that could help to get more persons accessing it, or what are the constraints that you're seeing? You mentioned the legislative part of it to do with the restorative justice, but is there anything that you would want to...
Chairman, could you permit me to just make a little comment before you get the answer? Notwithstanding how hard working your minister is for those things that you need, our job here is to help your minister. So don't be restrained in answering the chairman in that question.
No. And when we see good programs like this, it is for us. I keep reminding MDAs that appear here at the PASC that it is not for us to just complain of what is going wrong, but to support some of those things that are going right.
Good, thanks. Okay, Chair, one of the challenges that we have is identifying suitable locations, but that seems as if we're heading to some solutions based on the offers that are being made here today. But sometimes we do have issues with identifying suitable locations to build out and set up a center to offer the services. So that is one of our challenges.
But before you move on to the other, because one of the challenges that I see government overall has, and I use Manchester as an example when you're trying to relocate your court, is that government has a cap on rental per square foot. In today's economy, gives you a corner shop probably in the market, but not somewhere that is suitable for. So that in itself is an issue that you face. Hence why you may not be able to find suitable locations.
Sure, and as well as persons being able to access the service, because we also have to think of persons with disabilities, the elderly, and so on. So sometimes you may find somewhere, but it's upstairs or so on. Manchester, for example, our Justice Centre in Manchester, in Mandeville, is now located on the 3rd floor of the post office. We're currently seeking earnestly to identify another location to relocate that centre. But again, the challenge is in identifying a suitable location.
Being that you're going to be constructing a new courthouse in
as
Manchester,
well as
you will now build a facility for
a Justice Centre, for the co-location of all the services.
Once you're building new courthouses, then it ought to be in the design of these facilities, so that you have a one-stop shop for everything.
A one-stop shop for everything.
Sorry.
No,
Yes?
No.
On that point, go ahead.
Another challenge currently is the need for an integrated database system, so we can quickly, in real time, record, retrieve information on our clients and, track and monitor. So that is another. But we're working with some donors currently to see because DOJ is not able to really give all the funding that is needed.
But aren't you doing something like that to upgrade the courts?
Yes. Yes.
So why
but
couldn't
it's not.
it be?
It's on a different kind of platform, and the courts really want to keep their data.
No. What I'm saying is that is replicating it for years.
Social justice services.
Yeah, exactly. Right. So it's not really bringing the courts using the same system, but replicating it for that purpose.
That's
so since you are already in the market doing that for the courts, why not then dovetail for that purpose, for the restorative?
For the well, we are seeking a system that will carry all the social justice services for child diversion, restorative justice services, victim services, all of those social services that the ministry is.
Greater point is that you may not have to go to recreate the wheel while you're already.
That's correct.
Doing it. Yeah.
So, and of course, well, COVID has come with its own challenges to our programs. And of course, we have been doing some workarounds and innovations. And I know, for example, for restorative justice, some of the trainings must be done face-to-face. And so those are some of the challenges because of the numbers of persons who you can accommodate and so on. What can be done virtually is done virtually, but the training for some of our facilitators and practitioners have been reduced. But we're trying to find some creative ways to deal with those. Those are the main challenges at this time, ladies.
And in Manchester...
service providers for child diversion.
Service providers.
Yeah, the service providers, and they come at a cost.
Explain. Yeah. Explain on the service providers.
Carrie Lewis, to speak to those challenges.
What we have found is outside, even to some extent, government, but basically all of the service providers have some cost as it relates to treating our children. So even when we make a call for persons, organizations that are interested or individuals, there's always a cost assigned to it. So we did get to some extent a reasonable allocation, but we do have children that require more intensive support to really see a change in the behavior. So even as it relates to psychosocial care, for instance, they need a longer treatment program to really have the change that we want to see, right? And that requires funds. So even though we've been able to negotiate with mental health professionals at a really reduced cost, we still need an increase in that. That's one. And the other issue that we found, our compliance rate is low. We have a 5%, I would say, non-compliance in terms of the numbers for last year, which is pretty good. But where there are challenges is that the reality of the country is that a lot of persons and parents and guardians really can't travel to get treated. So what we've tried to do as a result of COVID is have all of the treatment providers come on the same day to our center for the service. But in order to get the intensive care that they need, they really need to have funds to be able to make it. You know, transportation, sometimes meals, or we have to provide. So we do kind of have to now look at having a welfare fund to help with some of the families that are in the program.
Which is just a reality.
Which is a reality, and there's always a cost related to it. And secondly, our children stay in their home. That's one of the benefits of child diversion. They stay in the home for treatment. They're not in an institution. And when you're treating a child and they have to return to a home where they may not have a bed to lay on, they may be sharing a room with 4 other children, they don't even have a tablet or a phone, it means that we have to find a way to provide for them. So we need to get some type of welfare program support built into the program to really improve the compliance of the children.
Well, we look out for that in the next budget. Yeah?
I just wanted to... Sorry.
What I'm saying is, Chairman, I don't think people recognize the extent to which children are having serious problems under 13 years old, which become critical problems before they even get to 18. And what Mrs. Carey Lewis is speaking about is it's not even a virtual reality.
Mm-hmm.
It's a new normal in Jamaica, and COVID has
especially
exacerbated.
COVID has, exactly.
So the welfare fund is one thing, but if you take into consideration that 50% of the students who are in school are already on path, what it also gives to us in this committee is the reality of how parents are coping in circumstances where they too are pressured and stressed, which causes more to bear on the child. And it's one thing to come to PAAC and to the other committees and to look at legislation which deals with diversion and mediation. But until we get to a point where we recognize that the generations that are coming forward need critical care mentally, emotionally, they need stability and resilience, we will be coming here to put band-aid mechanisms on a culture which will be out of control. And so I think from this committee, I want the report to reflect very carefully that while the Ministry of Justice is speaking to these issues, there has to be some kind of interministerial coordinated approach. The member simply spoke about a cost-benefit analysis. But we have to get to a point where nationally, the Ministry of Justice, the Ministry of Education, the Ministry of Health, National Security are looking at the coordinates that are linking children to having this kind of, whether it's uncontrollable behavior and different systems, and really address it. Because if we don't address it, what you will have are the end factors with crime, and crime alone is robbing us of a large percentage of GDP and growth. So until we fix this issue, it is really going to be a stain on us as leaders and a stain on what we do and how we achieve our mission. So I want that to be in the report. I think certainly Grace and Charmaine knows, and sorry for calling by first, but they know how passionate some of us are about these things. And it has to be fixed. We have to get to a point, and if we are going to be the catalyst at this committee to say, look, enough is enough, it has to start here. So you need to come back and tell us what really is a realistic budget to address the restorative justice system, to address the mediation system, to look at what it is going to cost a family. We hear that it is $8 million to run Maxfield Park Children's Home every month. But what is it to really get a family from point A to point B who is dealing with mediation? What are the factors for them to eat? What are the factors to get them to understand and to congeal as a family unit so that they don't end up in conflict again? And if we can arrest the development of that kind of existence in this country, I think we would have done well as legislators.
Those last point by a member, and I really want to strongly add my support to. But two quick things. The question and answer the chairman on regarding the needs, and you mentioned about space. Do you, I presume, do some forward planning? So you could say, by another year or two, you need a space here and there, so that we as members of parliament, for example, could, even for development, take Portmore, development take place, I'd say, try to secure a space here or something like that, so that you are, ahead of the competition for space that you need. Because these are vital services that we need in the community. And secondly, for persons coming through the mediation process or even the restorative justice process, is there any kind of tracking system in place so that, 3 months, 6 months, a year down the road?
It's here on page 6.
Oh, sorry. Okay. I missed that in the summary.
Yeah. There's a follow-up on the cases here. If you read page 5, it also explains that even after 6 months after, they are still following up. If there are any payments to be compensation or anything, they follow up. So it is here. But what is? I was looking at it earlier and trying to understand it. The table 2. Because again, I was looking at the numbers, and you see I marked it. St. Mary and St. Anne had a higher number. So if you can explain how these numbers are calculated, so I can better understand.
Thank you for the question. With regards to the follow-ups, you will note that St. Mary is higher and also St. Anne. That has a lot to do with the number of facilitators that support us in those centres. So due to the staff, they're able to follow up on more cases, so we get more of an outcome. But this table, I just want to say that this is quite important because not only do we have the data to say, for example, in 2021, we followed up with 3,115 people, but we also have the data to say that, 12 weeks, 6 months, and even a year later, out of that number, 3,083 were still on a successful agreement. There was no further conflict that had arisen, and peace had reigned. So that's very important data to show how successful the program really is.
Mm-hmm. Okay. All right.
COVID responsible for the low number for 21 so far?
Yes, definitely. Thank you, member. The courts were closed for a period of time, and that did impact on the amount of referrals to us. And of course, for a period, we did suspend operations due to gathering limits and so on.
All right.
Thanks.
Okay, members, I think we have had a very good meeting here today. Let me thank the Ministry of Justice and the team, Madam Acting PS. Thank you very much. Mr. Osborne, Mr. Bailey.
Security.
Security.
We heard from everybody else but you, sir. I don't think it is because you're the only.
We had our backs.
But I'm the director for victim services. I suppose the next time around you will require information.
Yes. No, for sure, because I think there's much more in the report that we can go into. But thank you again. I think this was one of a very fruitful interaction.
Chair,
Yes,
just to remind that we're still looking for the information for the DRS mediation intervention.
All right. So thank you again, and have a good afternoon. Thank you. Members. Oh, and I just wanted to mention Manchester. There's a youth information center on Winch Road that is locked up. Speak to the Ministry of Education and see if you can use it. Yeah? It has been locked up for a while. So it's on my side of the border. No, the road is the border between Northwest and Central Manchester, but it has been locked up for a while. So maybe there's enough room there to be able to use it and still have facilities if they want to use it again. Just came to mind. Members, is there any other business? No other business. Thank you, members, for making this, I think, a very productive meeting. The date of the next meeting would be Hart on the 28th excuse me? No, but we all sat down here and we agreed on the 28th, so we will keep that date as the dates are hard in coming now until something changes. This meeting is adjourned.